Welcome to the Deep Dive. Today we're tackling something really important if you're renting in California.
Yep, California Law Tenant Rights.
We've gone through the official guides, the legal summaries, all that dense stuff.
And tried to pull out what you really need to know. Because, let's face it, landlord-tenant law can feel pretty overwhelming.
Totally. So our goal here is just to make it clear, give you the key info to empower you as a renter.
Exactly. We'll hit the big things.
Like your right to a decent, livable place.
And your privacy, your exclusive possession.
Big one, protections against discrimination.
Absolutely. And the rules around rent, security deposits, money stuff.
Definitely need to cover repairs when the landlord can come in.
And importantly, how tenancies end, including, the eviction process.
Okay, let's dive in. Where do we even start? What are those foundational rights?
Well, first off, you get what's called exclusive use and possession, meaning it's your space while you rent it. Even though the landlord owns it, they can't just pop in whenever.
Right, that makes sense. It's tied to your rental agreement, like a lease or month to month.
Precisely. And those are different. A lease gives you stability, locks in the rent for, say, 6 months or a year.
So no surprise, rent hikes mid-lease.
Generally no, unless the lease specifically allows it somehow. And leases over a year have to be in writing here.
And month to month. More flexible.
More flexible, yeah. But the rent can go up with proper written notice.
Okay. Before you even sign anything, like during the application, are there rules there?
Oh, yes. California wants fair screening. Landlords can charge an application fee, sure, for credit checks and things.
But
if they turn you down because of your credit report, they actually have to tell you why, in writing.
Huh. Okay. What about criminal history?
They can't just have a blanket no felons rule, for instance. It has to be based on convictions directly relevant to being a tenant.
And applied consistently to everyone.
Exactly, which leads right into discrimination protections.
Which are strong in California, right?
Very. Landlords cannot refuse to rent to you or treat you unfairly based on race, color, religion, sex.
Sex includes pregnancy, gender identity, yes?
Also sexual orientation, marital status, national origin, ancestry, having kids, source of income, even age, disability, medical condition. It's broad.
That's really crucial. Equal access.
Fundamental.
All right, let's switch gears to money. Paying rent. Any specific rules?
Well, they can't usually demand cash only, unless, maybe you bounce checks before.
Makes sense. And rent increases, especially month to month.
They need to give you proper written notice first. The amount of notice depends on how big the increase is.
But there's also that statewide law, AB 1482.
Yes, super important. That generally caps annual rent increases. Think 5% plus the local inflation rate, or 10% total, whichever is lower.
Wow, that's significant protection against huge jumps.
It really is. Doesn't cover every single rental. There are exceptions, but it applies to most.
Okay. Security deposits, another big money item. How much can they take?
Usually not more than 1 month's rent for the deposit.
Here's
There's a slight exception for very small landlords, maybe 2 properties, 4 units max. They might get up to 2 months.
But there's a cap.
Oh, yeah. And for active military members, it's always capped at 1 month's rent. No exceptions there.
Good to know.
Yeah.
And getting it back, the 21-day rule.
That's the one. They have 21 days after you move out to return your deposit.
Or
give you an itemized list of deductions, unpaid rent, damage beyond normal wear and tear, with receipts if possible.
Normal wear and tear. That phrase causes arguments, I bet.
It definitely can. It basically means the gradual decline that happens just from living somewhere normally.
Like faded paint, worn carpet.
Exactly. Not holes in the wall you punched or, a broken fridge because you misused it.
So how do you avoid disputes over that?
Smart move. Request a pre-move-out inspection. You have a right to one about 2 weeks before you leave.
So you walk through with the landlord.
Yeah. They point out what they might deduct for, and you get a chance to maybe fix it yourself first.
That sounds incredibly useful. Okay, so while you're living there, privacy, landlord entry.
Right, back to that exclusive possession. They can't just walk in.
What are the legitimate reasons then?
Emergencies, obviously. Necessary repairs. Showing the unit to potential renters or buyers. Things like that.
But not just because they feel like it.
Definitely not. And usually, unless it's a true emergency, they need to give you written notice.
How much notice?
Typically, 24 hours written notice is required, and you can't waive that right in the lease, by the way.
Okay, reasonable notice for specific reasons. What if something needs fixing? Repairs.
Huge area. Landlords have a legal duty, the implied warranty of habitability.
Meaning the place has to be livable.
Basically, yes. Safe and livable. Working plumbing, heat, electricity, weather protection, secure doors and windows, no major pest infestations, no dangerous mold.
Even if it wasn't perfect when you moved in.
Doesn't matter. The duty applies throughout your tenancy.
So what if the landlord doesn't fix things after you tell them? In writing, I assume.
Always notify them in writing first. Keep a copy. Then you have options.
Like what?
One is repair and deduct. You pay for essential repairs yourself, then deduct the cost from the rent.
Are there limits?
Oh, yes. Strict rules. Limits on cost, how often you can do it. It's not for everything.
Okay. What else?
Rent withholding. This one's riskier. Probably want legal advice first.
Because you stop paying rent.
You withhold it, yeah, if the place is seriously uninhabitable. But you must set that rent money aside. You might need it if it goes to court.
So it's not just free rent.
Not at all. In really bad situations, you might even be able to break the lease and move out. Or sue the landlord for damages.
Documentation seems key here.
Absolutely critical. Written requests, photos, dates.
Right.
Everything.
Okay. Moving on. What about actually moving out? Ending the tenancy?
If it's month to month, you usually give the landlord 30 days written notice that you're leaving.
And if the landlord wants you out? Month to month.
They also give notice. 30 days if you've lived there less than a year, 60 days if it's been a year or more.
And fixed term leases.
They just end on the date in the lease, usually. A landlord can't typically end a lease early without a specific legal cause.
Like not paying rent.
Exactly. Or seriously damaging the place, or other major lease violations. Which brings us to eviction.
Yeah, the tough topic. What's the actual legal process in California?
It is a legal process. Landlords can't just, lock you out or throw your stuff on the curb. That's illegal.
So what do they have to do?
First, they have to serve you with a proper written eviction notice.
Like 3-day notice.
That's the most common one, yeah. A 3-day notice to pay rent or quit if you're behind. There are other notices for fixing lease violations or sometimes unconditional quit notices for really serious stuff.
And if you don't comply with the notice, pay the rent or move out.
Then, and only then, can the landlord file a lawsuit in court. It's called an unlawful detainer action.
So you get sued.
Yes. You'll be formally served with court papers, a summons, and complaint. Usually have only 5 days to file a formal response with the court.
5 days is not long.
It's incredibly fast. If you don't respond, the landlord likely wins by default.
And if you do respond, or if they win anyway?
The court issues an order, a writ of possession. The sheriff posts this on your door.
Giving you a final warning.
Usually 5 more days notice from the sheriff before they can physically remove you and your belongings. It's a very serious process.
Absolutely. Getting that notice, responding, it's critical.
Crucial. Don't ignore legal paperwork.
Okay, this has been a really vital overview, especially the eviction details.
It's complex, but important to grasp the basics.
And just a reminder for our listeners, particularly if you're a tenant in Orange County, Riverside, San Diego, or Los Angeles, California, and you're dealing with eviction threats, an unlawful detainer lawsuit, or even premises liability issues like unsafe conditions in your apartment.
Right, those specific situations.
You can find more focused information and resources at martinezlawcenter.com. They specifically work with tenants on those issues in those counties.
Good resource to know for people in that area facing those specific problems.
So wrapping this up, what are the absolute key takeaways for California renters?
Okay. Number 1, you have a right to a safe, habitable home. That's fundamental.
2,
strong protections against discrimination exist. Know them.
3,
rules matter for security deposits and rent increases, especially AB 1482. Don't get overcharged or have deposits kept unfairly.
4,
your landlord needs proper notice to enter and proper notice to end your tenancy or evict. They can't just decide on a whim.
and 5.
Eviction is a strict legal process. Know the steps and your right to respond.
And underlying all of this,
Document everything. Your lease, letters, emails, photos. Communicate clearly, preferably in writing.
preparation and knowledge are power here.
Absolutely. California law does offer significant tenant protections, but you need to be aware of them.
So a final thought for everyone listening, considering all these rights we've discussed, from habitability to the eviction steps, what's one area you feel is the most critical for California renters to truly understand inside and out, and why?
That's a good question to ponder.
Something to think about. Thanks for tuning in to The Deep Dive.
Call now 71444429741. Thank you.